people often think, oh, wow, I'm writing a blog. What's a good picture for this blog? Or I'm writing, an article about something to promote my product. I'm going to utilize this image of this, celebrity. Obviously, you're not going to use a. You should not use a picture of a celebrity without their consent. Okay, so hopefully that goes without saying, because you don't have their permission. In simple speak, you got to ask for permission before you do these things. But just in regards to images, let's say it's a particular image of a nice view that you found in a Google search and you utilize that. You can. I mean, you can, but you can get sued for copyright infringement because that is a work of authorship of someone else.
Welcome back, everybody, to the From Crisis to Justice podcast. I'm your host, Parag Amin, and I'm joined by a friend and special guest, Michael Cohen. He is the founder and principal attorney of the Cohen IP Law Group. He represents Fortune 500 and mid-sized companies, as well as emerging startups and entrepreneurs. His practice largely involves intellectual property prosecution and litigation, particularly in patent and trademark matters. He's a licensed patent attorney. He is an AV-rated attorney by Martindale-Hubbell, a ranked super lawyer by Thomson Reuters, and he specializes in internet and domain disputes and cyber squatting issues. So I'm really looking forward to getting into this today with you, Michael. Thanks for joining me.
Thanks for having me.
So how did you get into intellectual property law to begin with?
Well, I guess it goes back to the 90s. So I'm dating myself a little bit. When I was in college, I was going the pre-med route. I had a father who was a physician and came from a long line of physicians, and in my family, I think a lot of other people can relate to this, where there's a lot of pressure for them to go a certain route. And my brother didn't go to medical school. My sister became a lawyer. And so I was the last hope for my father. So I was in school and I was pre-med. I was, studying chemistry. And I realized I was getting straight A's in all my non-science classes and not A's in my science classes. And so my final year, I said, I'm going to pause and think about this. And so I took the MCAT, but then it was 1996, and it was the beginning of the .com. It was right at the inception of that. People started to get cell phones for the first time. So I had my first cell phone in 96. And so I decided to work. I worked for a local tech company. They were a manufacturer of DRAM and SRAM. And I was in-house over there as the director of purchasing, and I learned a bit about technology, and I saw that whole world. I was exposed to that. And at the same time, I had a really good boss who I'm occasionally in contact with, great guy. And he had this attorney come into the office every so often to have conversations with him. And I asked him, well, who is that guy? And he said, well, he's my patent attorney. And I said, what's that? And this is 1996, so no one really knew the phrase patents and trademarks as much as people do know it now. So I said, what's that about, and how do you become one? And so I learned a little bit about the process of that, and I learned that to become a patent attorney, you need a science background. So you have to have an undergraduate degree science background, or at least qualify in some other way to sit for the patent bar, which I was able to do. So I knew I wanted to eventually go back to some kind of graduate school. And I thought, wow, intellectual property is an interesting area. I'm already in tech right now, and it seems like a very promising area. I can help businesses. I wasn't so much about, maximizing my money, and, there's nothing wrong with the other areas of law, but I really wanted to do something where I felt at least there was some altruistic component to it. And what better than a capitalistic philosophy of helping small businesses the best that they can to utilize their technology, their creations, their intellectual property. So I thought it was a no-brainer. So I thought this is the way to go. I can qualify for this, and it'll be something that I believe in. So I did it. So before law school, I was probably one of the few people that knew what they wanted to do. A lot of people go to law school, they're not so sure, what area of law they're going to practice. But that's what started it. Um, so I did. So I applied and I went, and that was the route that I took.
That's great. And so, can you tell the listeners, if they're not completely familiar with exactly what intellectual property law is, or they've got some idea of what it is, but they're not exactly clear, can you sum it up for everybody?
Yeah, sure. So it is an esoteric area of law that people get confused, frequently with what it is. So, simplistically, I guess you can say intellectual property is the protection of things of the mind, and being intellectual, whereas real property is the protection or the study of the area of law of real estate and tangible things, right? So the intangible is what we focus on. And the intangible things are creations, inventions, art. It could fall into that. So intellectual property is that big umbrella of sub areas of patents, trademarks, copyrights, and trade secrets. Those are the big four. There's some other areas as well, but those are the main ones. So for example, in the story I gave earlier, my boss, I didn't explain what the patent attorney was doing, but my boss had this invention to help carry a laptop. It was some handle, and it wasn't anything that revolutionary, but he wanted to protect it, and so he would protect it through filing a patent for it. And he either filed a utility patent or design patent. I don't know what he ended up doing. And so his patent attorney was the one who advised him on that, how to describe it, what it was, and then file for it with the right agency, which is the United States Patent and Trademark Office. And then it goes on to issuance, and then you gain benefit from all the rights that are bestowed upon you from getting it.
Yeah. So, in terms of patents, I've heard it described this way. It's like the really either the design or the execution of your idea, as opposed to just the idea itself. Do you agree with that?
Yeah. So that's we commonly say that ideas in and of itself are not necessarily patentable. Okay, so if you have a broad, vague, general idea of, frequently I have clients who have some method of practicing business that they want to capture. And they say, well, no one's ever done this before. No one's ever, what was the big one? Well, I'm going to put advertisements in the men's bathroom. Like that's a new way of doing it. And maybe you're right, but is that patentable? Okay, so not everything is patentable. So just the idea itself is not. It's the manifestation of the idea. In regards to patents, now other things is a little bit different. But in regards to patents, we're talking about inventions. That's the key. So patents are about inventions and what qualifies as an invention. And so you have to describe what the invention is in a patent application, and you have to thoroughly describe it. And the legal standard is so that one of ordinary skill in the art can make and use the invention. Okay, so what that amounts to mean is that are you describing it sufficiently enough so that someone who is in that area can understand what it is and practice it. Okay, so it's not enough just to write a one sentence or a one paragraph description of what your invention is and claim that's yours forever. You have to go through the process and really describe it. And there's this whole back and forth for utility patents. Now, there's other kinds of patents too. And there's design patents, there's plant patents, there's something called provisional patent. So it just depends what we're talking about. And, everyone's different with what they want to protect.
Yeah. So we just talked about patents. Now let's briefly talk about trademarks. So trademarks, is that the protection of a brand and relating to consumer confusion, or can you talk a little bit more about what specifically trademarks are and what they protect?
Yeah, sure. Yeah, it is that, and it's so much more. So I think trademarks is more relatable to the average business person because it's not as it still has a lot of nuance to it, but it's not as complicated as the patent process. So trademarks is mostly about the brand. Okay. And when you think of a brand, for example, you think of Nike is the classic example that everyone thinks of. That's their trademark, the name Nike, but in connection with particular goods and services. Okay. So trademarks are always about the name or the association of that name in connection with what they do. What are the goods or what are the services that they have? So people affiliate the Nike with sporting goods or clothing, things like that. Um, a logo so that's a name, and then a logo obviously could be a trademark, so the Swiss symbol. A slogan, just do it, is also a trademark. A jingle could be a trademark, so like the classic one is the NBC do do do. A color, in some cases, it's harder, but could a color could be a trademark because if it's associated with a particular brand and there's meaning in the public, secondary meaning in the public to associate that color with that brand.
So, for example, maybe Tiffany blue or Louis Vuitton red bottoms.
Those are the two big ones, of course. The fashion ones are the ones that everyone thinks of. Yeah,
Yeah, and
yeah.
and then there's copyrights. So, could you talk a little bit about what copyrights are?
So copyrights moves into another area it's relatively broad, but usually I think people think of it in the context of arts or music. So copyrights is really anything that is a creative work, original work of authorship that can be fixed in a tangible medium of expression. So what does that mean? So essentially, if you make something, so for example, a work of art, okay, you draw something, you put pen to paper, you create it, you have a copyright on that, and you automatically have a copyright on that by default, okay. So the law says that you automatically have a copyright. It's not a registered copyright, but it's by default a copyright, okay. So works of art, photographs, music, and music. There's the composition of the music, the the notes, everything can be typically protected in the form of copyright. Movies, even blueprints, so architectural work, and then it extends to there's some other areas where there's a blurry line between design patents and copyrights. So, for example, some jewelry can be protected through copyrights, whereas also design patent could as well in some cases. So there's some overlap in some of the areas of law, which leads to some strategy in regards to, okay, well, what do we file and how do we file and when can we file, or are we disqualified from filing because not everything qualifies, and for some things there's deadlines to file. So it's critical that whoever has something that they want to protect, they consult with counsel to see, well, what do they got and how can we protect it, and is it too late to protect it too?
Yeah, and let's talk a little bit about that. How does a business owner know that they've got something worth protecting, and how much approximately does it cost to go through this process? Because, for example, I've heard from business owners who have ideas at the very early onset, pre-revenue, haven't executed on it, haven't made any money on it, and they're considering going out and getting patents or potentially registering their trademark. And then on the flip side, I've seen business owners who are now years into business, many millions of dollars of revenue later, and they haven't applied for their trademark or patented any specific technology that they're using. And so, can you talk a little bit about the cost benefit analysis of when a business owner realizes, look, I've got something that's worth protecting, I've got something that's worth investing money into to help protect, and how that analysis should go?
Yeah, as an entrepreneur, often you're not going to know what you can protect or what you have. You may not even think about it, or you may have a friend that says, "Oh, you have something. Go see a lawyer." So the first step is, consulting with a lawyer, an experienced IP lawyer. Obviously, that goes without saying, and hopefully that attorney will issue spot, see what you have, and see what can qualify. Okay, so if you're a tech entrepreneur, for example, and you're creating some, let's say, piece of hardware that's unique or software, um, a lot of the times that could fall under the patent realm. It could fall under the copyright realm, and also the trademarks. So that any company can protect the name of the name of the company, or the name of the product, or the name of the service. So that's a little more straightforward. I can say, if you're a business owner, you have a product, you call it something, it's a trademark. That's pretty straightforward for the most part. Okay. Now, can you file for a trademark for it? Maybe, maybe not, because that name could be taken, or a similar name is out there. Okay, so trademarks get really nuanced in regards to what name you pick, and so just on that note, I think trademarks is I said it before, but it's a little more relatable to the average business person, and that could easily be the first step. You know, and you can file a trademark very early on without launching the product, because there's mechanisms for that. The intent to use application, for example. But you got to search the name. You got to clear the name. Clearance is such a huge issue that, if there's one takeaway from this conversation, trademark searches by experienced trademark counsel is a must. It's not something you can, there's a public database, the USPTO, but we don't use that, so we have a proprietary database, and as a layperson, you can go on there and take a look, but you don't know what you're looking at, because there's live names, there's dead names, there's likelihood of confusion. You don't know what the standard is. You pick the wrong name, you could be screwed royally. And I've had clients that have been screwed, particularly people who were not my clients in the beginning, who came to me later, and I had to tell them bad news. For example, I had a client who purchased a premium domain name for $10,000. Okay. He was going to launch, I think, a clothing line. He wasn't my client when he did that. Then he found us and said, okay, we want to file a trademark for the name of the brand. And I said, okay, well, we need to do a search first. We did the search. It turns out the name that he wanted, which was in the domain name, he couldn't use it because there was a pre-existing brand, and he would get sued immediately. And he just wasted 10 grand. Okay. There's even worse stories than that. There's people that have hundreds of thousands of dollars of inventory in some warehouse, and it has an infringing name on it, or it gets stuck in customs. We've had that happen too, and then we have to deal with the customs and see if we can, talk our way out of that. So you don't want to be in that situation. You want to be in a situation where you're proactively making moves and making decisions about the products or the services, and having IP counsel clear things. So trademark searches, doing the patent search, and anything else that is related to the goods or the services.
Yeah, it can be a very expensive mistake. Some examples you've just described, as well as I've heard of even trademark lawsuits or copyright infringement lawsuits when people have, for example, reposted on their Instagram stories. Let's say it's a celebrity wearing their clothing or their brand, and they'll take that photo and then post it on their Instagram, or on their stories or on their feed. And this could be any social media platform. I'm just using Instagram as an example. Can you talk a little bit about the analysis and the legality of using photos of other people? I mean, why is it not legal to take a photo, whether you found it on the internet or elsewhere, if the person's wearing your brand? Why is that wrong?
Just yesterday, or actually today, I had to discuss with opposing counsel. We're retained last week by a client who is exactly in that position. They have a business and they have a blog and they posted something and someone else is claiming that they own the copyright to it. And it's a picture of a celebrity, and then so the other side is claiming copyright infringement. So now we have to deal with that. It's a very, very common thing. So in regards to photographs, we're dealing with the internet now. So everything is online. Whatever you post, it's there for a long time, forever theoretically, unless you take it down. And you just can't take things off the internet. So people often think, oh wow, I'm writing a blog. What's a good picture for this blog? Or I'm writing an article about something to promote my product. I'm going to utilize this image of this celebrity. Obviously you're not going to use you should not use a picture of a celebrity without their consent. Okay, so hopefully that goes without saying, because you don't have their permission. In simple speak, you got to ask for permission before you do these things. So but just in regards to images, let's say it's a particular image of a nice view that you found in a Google search and you utilize that. You can't. I mean, you can, but you can get sued for copyright infringement because that is a work of authorship of someone else. So, some photographer clicked the button on their camera, took the picture, and what I said earlier, they automatically own the copyright. So if that photographer goes out and files a copyright, they can now sue you for copyright infringement because now you're promoting your product or service for monetary gain and you're utilizing that image in some fashion. And guess what? It doesn't have to be a massive use. Okay. So I think the very common notorious ones are the Getty images, and there's a lot of those kind of pictures that you're supposed to get a license for, right? So you can, if you want to utilize an image, you can, and you can go to these companies like Getty Images, and there's a whole host of other ones where you pay a royalty, and oftentimes it's not that expensive. It might be $10 for the use, or it could be more. But if you don't, let's say you found that same picture somewhere else and you didn't pay the royalty, they have software that scans and they can find these images. And they send out hundreds or thousands. There's law firms that represent them, and they send out hundreds or thousands of these cease and desist letters. And some people call it a shakedown. Other people say it's legitimate, which it's within their right to do. But then you have to end up settling with them. You could be a dentist office, and you hired a company to make your website that's offshores, and you didn't think twice about what images they're putting on your website, and you can get sued for that because the internet company, the web developer, didn't think about that. They're not using licensed images.
Yeah, so maybe we can talk through an example here to help clarify it for everybody. So if I'm a photographer and I take the photograph of a famous celebrity, and let's say that famous celebrity is wearing my brand, me as the photographer, if I took the photo, I have the copyright. Is that right?
Yes and no. So it gets a little tricky, all right? So let's say there's a celebrity who is wearing your brand and you took the picture of it. Okay. So yeah, you would have a copyright on that image, but doesn't mean that you can use it because now what you're saying is, well, he's publicly endorsing me. Okay. But is that true? Just because he's wearing it doesn't mean it's a public endorsement for your product. And he may say, no, I get paid millions of dollars for endorsements. Just because I'm wearing this, it doesn't mean that I'm a spokesperson on your behalf. So it could go a little bit of both ways. Now, if if it's newsworthy and you're not promoting it on your website to sell the product, that could be a little bit different. And he's wearing your brand. Well, okay, a paparazzi took a picture of him. He just happens to be wearing your brand. It is what it is, obviously. Um, but but you cannot get an endorsement for someone without their permission.
Right. So let's clarify, because I think what you're talking about, Michael, is the misappropriation of name or likeness, or the right to name or likeness, right?
That's another area of IP. Yeah.
Okay. So the copyright, if I took the photograph or I wrote it, I have a copyright even if I have not registered it. Is that right?
Yes.
So this whole idea of you should send a self-addressed certified mail envelope to yourself to prove that you have a copyright. You've probably heard that. What do you think about this?
I used to hear that back in the old days. I haven't heard that for a while, but I'm sure people still think that. Yeah, there's all these kind of do-it-yourself myths about how to protect things, and the self-addressed envelope. You put the image in there and you send it, and it somehow verifies something. It doesn't. The only thing that protects in regards to photographs or images is by filing a copyright. That's what you can do, okay? Because and it's not tremendously difficult either to file a copyright, and it's not that expensive. It's it's one of the less costlier things to do in the realm of intellectual property. But yeah, it's a filing with the United States government, the Library of Congress. It's an official filing. It's time stamped, and you end up with an application number. So what else do you need? So that's the perfect thing. Don't mess around with anything else.
Yeah, absolutely. And so going back to the example, just to make sure it's very clear, I take the photograph. I have the copyright of the photo, but the question of whether I can then use the photo to promote my brand, that's a different question, correct?
Yeah, yeah. And there's some areas of the law where it does get weird like that. Yeah, yes, you own the copyright, but no, you can't utilize it. Same with patents. So you may be able to get a patent on something, but it doesn't necessarily mean that you can use it, because there might be a pre-existing patent on some other component of it. So there's some complexities in law where some of the IP overlaps, or there's some obstacle in the way that prevents you from utilizing what you want to use.
Right. So, for example, having clearance in one area of intellectual property, for example, let's say I have the copyright for the photograph, could still create issues in another area of intellectual property, such as name or likeness. Is that right?
Yeah, exactly. Yeah. So what you mentioned in that particular case is yeah, the NIL, name, image, or likeness, right? That's what they call it. And so you basically have to get permission from someone to use their image, and especially with celebrities. Celebrities, that's a very common one. I've been asked over the years. Hey, can I use this image of the celebrity? I'm going to even change it. I'll make an artistic recreation of this particular celebrity. Can I then use it? Then it gets into like another area. Well, is it a transformation? Then maybe, but still probably not, because they're very protective of their image, right? They make their money off of it. If you're, Tom Pitt, and you get paid millions of dollars to promote a coffee machine, and then someone else uses Tom Pitt's image, uh, or Brad Pitt. I'm sorry, I had Tom Pitt, confusing the two. Tom Cruise. you can't utilize his image for free. So it has value. His right of publicity is what they call it. It has a lot of value.
Right. And does it differ between, let's say, if the celebrity is still alive versus if the celebrity is deceased?
Yeah, it does, but it depends. So you cannot. Okay, for example, um, many years ago, I was interviewed by the BBC regarding Elvis, and Elvis impersonators were freaking out because there was some issue about whether or not there was a change in the law, and uh, and so just because the celebrity is dead, they're still in a state, and there's still aspects to the way that you utilize their image that you just can't go ahead and use. Okay, and they can come back and enforce their rights on that because they still own a certain degree of rights that you need to uh, pay for and have consent over or get consent to. So, but for other things, if it's like a historical person, no, so if it's so far removed that you likely don't need to worry about that. But for other ones, yeah, because there's still, Michael Jackson, his estate uh, guards, closely guards his trademarks. I was involved in a lawsuit many years ago regarding the filing of his trademarks by a third party, and they go very aggressively. At least back then, I'm sure they still do, but there's still value. They're still making money off the name and image of those celebrities. So no, just because they're dead or they passed away doesn't mean that you can now go and utilize their image for monetary gain.
Very helpful. So a lot of these people who are selling images, for example, Kobe Bryant outside of uh, crypto arena or elsewhere, if they don't have the rights to sell those from the estate, could they be sued for selling these images?
Yeah, theoretically they could be, but then you get into another kind of, business judgment type of decision that um, the handlers of these celebrities will take, which is, okay, well, number one, we got to pick and choose our battles. Okay, are we really going to go after these little vendors who are selling these things? I mean, a similar example is the knockoffs. So the Rolex knockoffs and Louis Vuitton purses and those kinds of things. You can go in downtown LA and see those kind of knockoffs being sold all over the place. And are they being stopped? Yeah, occasionally. They do, but it's like whack-a-mole. So they keep popping up, and it's hard to go after them. So they can only do so much. They have to pick and choose their battles, and sometimes they'll go after the main source of it instead because it's more important to do so. Um, Taylor Swift is a big one. I was just interviewed not that long ago regarding bootlegs. Uh, in front of her concert, there's people that are knocking her stuff off, and it's unauthorized product. So, what's the big problem with that? The big problem is that, well, what's the quality of those products? Is it a shirt that's going to rip the next day, and consumers will be upset, and they're going to say, well, this is an inferior quality product from Taylor Swift, and it somehow tarnishes her reputation? Yes, another aspect of it. So these companies may not go after everybody, and to some degree, there's a little bit of, well, is this more for the adoration of the celebrity, or are they just really making money? So are they going after fans who are just celebrating that particular celebrity versus a company who's selling knockoffs? And there's a little bit of a distinction between that. Um, so so these companies will pick and choose what they do because they have a budget too. They can't go after everyone. It's expensive for them to hire attorneys to go after the whole world. So they have to make their own economic and budgetary decisions in regards to who they're going to enforce against.
Yeah, no, absolutely. And these things can get very expensive if somebody makes a misstep. I mean, I understand that sometimes the calculation's made that it's not worth it for the brand, or that it's very difficult to go after the person who's creating these infringing products. But would you say that it's more likely than not that they're going to go after a person or individual or a company that seems to be successful and is pretty stable?
Yes and no. And then, another aspect is could have backfired on them. So what was there was the Jack Daniels case where it was oh my
The
God,
dog
there was
toys, right?
yeah. So so Jack Daniels going after them, would it look bad if they went after them? And so sometimes it has backfired. I've seen demand letters where the other side uh, there's more sympathy garnered for the other side because they're saying, come on, no one believes that you two are associated. And that could be the case more of parody type of cases, right? Where they're kind of making fun of the main brand, or they're lightly making fun of it in a comedic way, and they have a separate product, but the main brand is upset because they say, well, we don't want any affiliation between the two. So it could backfire, or the attorneys could be smart, and sometimes I've seen a comical demand letter. I think it may have been Jack Daniels who sent a comical demand letter to the other side, and the demand letter became famous in and of itself. It made its rounds in, I think, like Above the Law or these other places, um, and so there's a little bit of PR rights that comes into play. What is the perception of our company going after this company, and then is it a bet the farm type of thing where you're going to completely demolish them, or is it just one product of many that we're telling them take it down, you don't have rights, or you can get rights from us, ask for a license, do it the right way. That's another possibility as well.
Yeah. So one never knows until it happens. So maybe the lesson and moral here is that make sure you check it out early so you don't waste a bunch of time, money, and effort needlessly, or invite a lawsuit. So Michael, if our listeners want to learn more about you or see how they can reach out to you, maybe for some advice on IP, how can they find you?
They can always find us online. They can go to our website at cohenip.com. That's Cohen IP, like intellectual property. And they can contact us there. We're pretty responsive.
Okay, awesome. And to the listeners, thank you so much for joining today. Hopefully, this is very helpful. Michael, I know that this is very enlightening and helpful in terms of fleshing out some of the esoteric and sometimes confusing ideas around intellectual property. So, thank you for making it more approachable, easier to understand, and giving us some of your wisdom and time today. Very much appreciate it.
Thank you so much. Thanks for having me.
Yeah, and to the listeners, if you like this content, please make sure you like and subscribe for more useful information and amazing guests like Michael for the future. Thanks again for joining us.